While being openly skeptical of rules for grant of bail, the Supreme Court on Monday said that there is a pressing need for a bail law in the country to streamline the grant of bails. The judgment in the case Satender Kumar Antil versus CBI, delivered by a bench comprising Justices Sanjay, Kishan, Kaul and Sundresh, while referring to bail laws in countries like the UK, highlighted in its judgment the dire need for similar laws in India. In this landmark judgment, the Supreme Court stressed the importance of the rule bail over jail and issued a slew of guidelines to prevent unnecessary arrests. The bench even went on to say that the code as it exists today is a continuation of the pre-independence one with modifications, and hoped that the union government would look into its suggestions in earnest. Underlining that bail is the rule and jail is an exception, the bench asked courts to come down heavily on police officers effecting arrest without due compliance of Section 41 and Section 41A of the CRPC dealing with arrest of persons. Section 41 speaks about when police may arrest without warrant. Section 41A deals with the procedure for appearance before the police officer, who is required to issue a notice to the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offence, and arrest is not required under Section 41. The court had, in a 2014 ruling, asked states to direct police not to make automatic arrests and instead follow a checklist as laid down in the sections. As per this, an officer, while arresting a person without warrant on a complaint, must record the reasons for doing so in writing. The Supreme Court had also laid down that the police officer shall forward the checklist duly filled and furnish the reasons and materials which necessitated the arrest, while forwarding or producing the accused before the magistrate for further detention. Failure to comply with this, the apex court had said, would render the officers liable to departmental action and contempt of court proceedings. The Supreme Court observed that jails in India are flooded with under-trial prisoners, the majority of whom may not even be required to be arrested despite registration of a cognizable offence, being charged with offences punishable for 7 years or less. The bench even said that the culture of arrest in India exhibits the mindset, a vestige of colonial India on the part of the investigating agency, notwithstanding the fact that arrest is a draconian measure resulting in curtailment of liberty and thus to be used sparingly. The court even noted that despite its directions in the 2014 Arnesh Kumar case, no concrete step has been taken to comply with the mandate of Section 41A of the Code. The bench pointed out that the Supreme Court had clearly interpreted the law in this regard, that it is not enough that to make an arrest, the police officer has a reason to believe, but the satisfaction for the need to arrest shall also have to be present. The court said that CRPC Sections 41 and 41A are facets of personal liberty under Article 21 of the Constitution. Presumption of innocence until proven guilty is another cardinal principle of criminal law. It said this while considering the application for enlargement on bail. Courts will have to satisfy themselves on the compliance of Section 41 and 41A of the Code, and non-compliance would entitle the accused for grant of bail. The bench asked all state governments and union territories to come up with standing orders for the procedure to be followed under Section 41 and 41A of the Code. The bench noted that such a move would not only curb unwanted arrests, but also the clogging of bail applications before various courts. A section of the legal community is, however, critical of the Supreme Court's call for these laws to regulate arrest and bail, and for passing the buck to the government to do what judges ought to do themselves. The court has held bail as a constitutional right and issued guidelines against unnecessary arrests. But the new law isn't needed to pull up erring trial judges or police. For more such videos, log on to the federal.com.